Now, senior national security reporter David Rode, former Deputy Assistant Secretary of State and author of the briefing book on Substack, Joel Rubin, New York Times chief White House correspondent and MS Now contributor Peter Baker, and staff writer at The Atlantic, Tom Nichols. All right, so Peter, there was just a White House press briefing. How did Caroline Leavitt defend the president's decision-making today?
Well, look, every time the president says something that seems completely contradictory, it's Caroline Leavitt's job to go out there and pretend that it's somehow consistent. And this is the trick for this war, right? He says one thing, as you rightly point out, 1 minute, and another thing, another. It wasn't that long ago we were talking about unconditional surrender. Now we're talking about negotiations, which are, of course, conditional. And it's in some ways, it's the uncertainty, which they say is intentional, may have some strategic purpose. Nobody can be 100% sure what Donald Trump might.
The Supreme Court has delivered a significant ruling that directly challenges the Trump administration's aggressive deportation strategy, creating one of the most consequential legal confrontations of this presidency. At the center of this dispute is the administration's use of the Alien Enemies Act of 1798, an obscure wartime statute that had only been invoked 3 times in American history prior to this moment. The court's intervention represents a rare judicial check on executive power in immigration enforcement, establishing that even national security claims must operate within constitutional boundaries. This case fundamentally tests whether presidential authority can override the Fifth Amendment's guarantee of due process for all persons within United States jurisdiction. The legal battle began when President Trump signed a proclamation designating Venezuelan gang members as subject to removal under the Alien Enemies Act, claiming their presence constituted an invasion of the United States. Within hours of this declaration, the administration began loading planes with alleged gang members bound for a maximum security prison in El Salvador. The speed and secrecy of these operations alarmed civil liberties advocates, who argued that the government was conducting summary deportations without any meaningful opportunity for individuals to contest their removal. The administration's actions represented an unprecedented expansion of executive power in peacetime immigration enforcement. U.S. District Judge James Boasberg initially intervened by issuing temporary restraining orders to halt the deportations, ordering the administration to return planes that were already airborne.
There's an advantage to that in some way, but it also means that, even he doesn't seem to know what he's doing or what he's going to do next. And because it seems to be so conditioned on the impulse of the moment, the thing he happens to see on TV, the thing somebody happens to tell him most recently. And I think that that's the kind of thing that is, really concerned both the allies and a lot of American officials who are not certain where this war is going.
So, David, should we even be asking about what the president is saying and what he means, or should we, in fact, be looking at the actions of this administration and the Pentagon, what they're doing with troops, how they're positioning
The administration's response to these judicial orders became a flashpoint in the constitutional crisis, as officials refused to turn the planes around and declined to answer many of the judge's questions. This defiance of judicial authority prompted Chief Justice John Roberts to issue a rare public statement rebuking calls for Boasberg's impeachment, affirming that impeachment is not an appropriate response to judicial decisions. The administration's resistance to judicial oversight signaled a dangerous escalation in the separation of powers conflict. The Supreme Court's April 7th ruling fundamentally altered the legal landscape by affirming that all individuals subject to removal under the Alien Enemies Act are entitled to adequate notice and meaningful judicial review before deportation. In an unusual alignment, even the dissenting justices agreed with this core principle, with Justice Sotomayor noting that the government itself had conceded this point during oral arguments. The court's per curiam opinion established that detainees must receive notice within a reasonable time and in a manner that allows them to actually seek habeas relief before removal occurs. This ruling effectively invalidated the administration's initial approach of rapid, notice-free deportations. However, the Supreme Court's ruling contained a procedural limitation that created new complications for detainees seeking relief. The court determined that challenges must be brought through individual habeas corpus petitions filed in the districts where detainees are confined, rather than through class action lawsuits in Washington, D.C. This venue requirement scattered litigation across multiple jurisdictions, particularly affecting detainees held in Texas, where judicial sympathy for immigration challenges may be limited. The procedural ruling gave the administration a partial victory while simultaneously imposing substantive due process requirements that the government had sought to avoid. The due process requirements established by the court reflect centuries of constitutional interpretation regarding the rights of non-citizens. The Fifth Amendment's guarantee that no person shall be deprived of life, liberty, or property without due process of law has long been understood to apply to all persons within U.S. territory, regardless of immigration status. Supreme Court precedent dating back to 1893 has consistently held that no person can be removed from the United States without some opportunity to be heard. The court's recent rulings reinforce this principle while adapting it to contemporary immigration enforcement challenges. The administration's implementation of the court's notice requirement revealed significant tensions between judicial mandates and executive compliance. When the government provided deportation notices giving detainees only 24 hours to respond, the Supreme Court found this timeline insufficient. In a subsequent May 16th ruling, the court determined that notice roughly 24 hours before removal, devoid of information about how to exercise due process rights, failed to meet constitutional standards. This second intervention demonstrated the court's willingness to police the boundaries of acceptable process in immigration enforcement. The case of Kilmar Abrego Garcia exemplifies the human stakes of these legal proceedings. Garcia, a Salvadoran man living in Maryland, was erroneously deported to El Salvador due to what the administration admitted was an administrative error. An immigration judge had previously determined that Garcia would face danger if returned to El Salvador, yet he was sent to the notorious Secot prison alongside Venezuelan deportees. The Supreme Court directed the administration to facilitate Garcia's release, but the White House has resisted compliance, posting on social media that Garcia is never coming back. This defiance of a direct Supreme Court order represents an extraordinary constitutional confrontation. The administration's handling of the Garcia case illustrates broader patterns of resistance to judicial authority. When Vice President Vance was questioned about Garcia's return, he responded by asking whether critics were proposing an invasion of El Salvador, a response that ignored the simple diplomatic options available for securing Garcia's release. The administration's refusal to cease payments to El Salvador for detaining deportees or to formally request Garcia's return suggests deliberate non-compliance rather than practical incapacity. This posture has led legal scholars to warn that the nation may be approaching a genuine constitutional crisis. The Alien Enemies Act itself presents complex questions of statutory interpretation and historical precedent. Enacted in 1798 as part of the controversial Alien and Sedition Acts, the law authorizes the president to detain and deport foreign nationals from countries engaged in invasion or predatory incursion against the United States. The statute had previously been used only during declared wars, the War of 1812, World War I, and World War II. The Trump administration's invocation of the act against Venezuelan gang members, absent a formal state of war, represents a novel and contested application of this dormant authority. The administration's legal theory depends on characterizing gang activity as equivalent to state-sponsored invasion, a characterization that conflates criminal organization with military aggression. While the State Department has designated Tren de Aragua as a foreign terrorist organization, this designation does not automatically trigger the Alien Enemies Act's extraordinary powers. The legal distinction between criminal enforcement and wartime authority carries profound implications for the scope of presidential power and the protections afforded to individuals within U.S. jurisdiction. Lower courts have responded to these developments with varying degrees of skepticism toward administration claims. Federal district courts have issued numerous orders blocking various aspects of the administration's immigration agenda, with the pace of judicial intervention far exceeding that of previous administrations. This judicial activism reflects courts' recognition that the administration's legal theories, if accepted, would substantially expand executive power at the expense of individual rights and judicial oversight. The accumulation of adverse rulings has created mounting pressure on the administration to modify its approach. The political implications of these legal battles extend beyond immediate immigration policy. The administration's confrontational posture toward the judiciary has energized its political base while alarming institutionalists who view judicial independence as essential to democratic governance. Calls for impeaching judges who rule against administration policies have proliferated among political allies, despite Chief Justice Roberts' clear statement that impeachment is not an appropriate response to judicial decisions. This rhetoric threatens to erode public confidence in judicial neutrality and the rule of law. The Supreme Court's handling of these cases reveals the justices' awareness of their institutional role in moments of political tension. By establishing clear due process requirements while accommodating some procedural preferences of the administration, the court has attempted to maintain its legitimacy across the political spectrum. The participation of conservative Justice Amy Coney Barrett in portions of the liberal dissent demonstrates that concerns about executive overreach transcend typical ideological alignments. This cross-ideological agreement on fundamental principles of due process underscores the constitutional stakes involved. The practical challenges of implementing the court's notice requirements have tested the capacity of both the immigration bureaucracy and the federal courts. The administration's initial attempts to comply with notice requirements were found inadequate by the Supreme Court, suggesting either incompetence or deliberate resistance. Meanwhile, detainees and their attorneys have struggled to navigate the complex procedural requirements established by the court's venue rulings, often facing compressed timelines that limit meaningful preparation of legal challenges. The international dimensions of these deportations add layers of complexity to the legal and diplomatic landscape. The transfer of Venezuelan nationals to Salvadoran custody raises questions about the extraterritorial application of U.S. constitutional protections and the administration's obligations to ensure humane treatment of deportees. El Salvador's president has openly mocked U.S. judicial efforts to monitor the treatment of deportees, creating a diplomatic environment that complicates enforcement of judicial orders. The outsourcing of detention to foreign governments may effectively insulate the administration from judicial oversight. The evidentiary basis for identifying individuals as gang members subject to the Alien Enemies Act has come under increasing scrutiny. Lawyers and independent investigators have found scant evidence of gang affiliation for some individuals targeted for deportation, raising concerns that the administration is using gang designation as a pretext for broad removal operations. The lack of individualized hearings means that these designations occur without adversarial testing of the underlying evidence, creating significant risks of erroneous deprivation of liberty. The expansion of expedited removal authorities under the administration creates additional tensions with due process requirements. While Congress has authorized streamlined removal procedures for certain categories of migrants, the administration's attempts to extend these procedures to individuals long resident in the United States exceed statutory authorization. The Supreme Court's rulings have focused specifically on Alien Enemies Act deportations, leaving broader questions about expedited removal procedures for future litigation. The financial and logistical costs of compliance with judicial orders have become points of contention in the administration's public messaging. President Trump has complained that the Supreme Court's requirements impose burdensome expenses and delays on removal operations. However, these costs reflect the constitutional price of operating within a system of laws, rather than arbitrary executive decree. The administration's resistance to bearing these costs suggests a preference for efficiency over legality in immigration enforcement. The role of the Solicitor General and Department of Justice attorneys in these proceedings has tested the boundaries of legal ethics and professional responsibility. Government lawyers have made representations to courts regarding compliance with orders and future deportation plans, only to have those representations called into question by subsequent events. The credibility of government counsel before the federal courts has suffered as a result, potentially complicating future litigation across all areas of administration policy. The Supreme Court's intervention in these cases demonstrates the continuing vitality of judicial review as a check on executive power. Despite the administration's efforts to characterize immigration enforcement as a zone of unreviewable presidential discretion, the court has consistently affirmed that constitutional limits apply even in matters of national security. This judicial assertiveness contrasts with periods in American history when courts deferred excessively to executive claims of emergency authority, suggesting institutional learning from past failures. The procedural mechanisms established by the court for challenging deportations will shape immigration litigation for years to come. The requirement that detainees file individual habeas petitions in their districts of confinement, rather than participating in class actions, fragments litigation and may limit the systemic impact of judicial rulings. However, the substantive due process requirements apply universally, creating minimum standards that the administration cannot evade through procedural manipulation. The human consequences of these legal battles are measured in the lives of individuals detained without adequate process and families separated by sudden deportations. The men sent to El Salvador's maximum security prison face conditions that may amount to torture under international law, with limited prospects for meaningful review of their cases. The psychological trauma of sudden detention and removal, without opportunity to contact family or arrange affairs, compounds the legal injuries inflicted by summary process. The institutional relationship between the presidency and the federal judiciary hangs in the balance as these conflicts continue. The administration's pattern of testing judicial limits, retreating only when absolutely required by adverse rulings, and immediately seeking new avenues for expanded authority suggests a strategy of attrition against judicial oversight. Whether the courts can maintain their authority in the face of sustained executive resistance will determine the future of separation of powers in American government. The Supreme Court's rulings in these cases ultimately affirm that the Constitution's protections cannot be suspended by presidential proclamation, even in pursuit of legitimate policy objectives. The requirement of notice and opportunity to be heard before deprivation of liberty represents a foundational principle that distinguishes lawful government from arbitrary power. As these cases continue through the courts, they will define the boundaries of presidential authority in immigration enforcement for generations to come. The path forward requires the administration to choose between compliance with judicial orders and continued constitutional confrontation. The costs of non-compliance extend beyond individual cases to the integrity of the constitutional system itself. When the executive branch defies judicial authority, it undermines the rule of law that protects all citizens and non-citizens alike. The Supreme Court has provided clear guidance on the minimum requirements of lawful deportation. The administration's obligation is to implement that guidance in good faith. These developments serve as a reminder that constitutional government requires mutual respect among co-equal branches and adherence to established legal procedures even when they impede policy preferences. The Alien Enemies Act cases will be studied for decades as examples of how the American legal system responds to claims of emergency executive power. The ultimate resolution will determine whether the constitutional constraints on presidential authority retain meaningful force in the 21st century.